Welcome everyone. We're going to get started in just a few minutes. Welcome everyone. We're just going to wait just one more minute and we'll be just starting in 1 minute. Thanks for joining us today. All right. Welcome everyone. Happy fall almost. Hope everybody's safe out there with all the different fires going on. My name is Anthony Wolin. I'm the owner of the Collective Realty. And so happy to have you guys join us today. We have a really great speaker. LA Multifamily Meetup has been going on for the last couple years. We have about 1,000 followers now. And we're really passionate as an office and team of bringing you education at least every month on all the important changes and things you need to know specifically around the LA multifamily real estate market. It's a business, new business that you're starting or have been in, or maybe you've been in for a long time, but there's always things that are changing, and we'd like to be your resource to make sure you are staying on top of what's important to your business as an investor in multifamily. So here we are in the middle of September, and we're have election season right around the corner. There's one proposition that I just wanted to start off to bring to everyone's attention, and I'm sure will have other election updates possibly to bring as well. But just to get us started, Prop 19 I want to talk about. You may not have heard about it yet, but you definitely will. Prop 19 was actually written by the California Association of Realtors and put on the ballot this year as something that we think as an industry that really is important and something that's really going to help many homeowners. So if you're familiar in the past with Prop 60 and 90, it was propositions that allowed you to transfer your property tax base once in your lifetime if you're over 55, and it had to be a transfer within the same county or counties that participated. I think there's 13 counties that participate. So it was a little limited and it could only happen once, but it was pretty great because as of right now, if you're over 55 and you sell your primary residence, you're able to move into another home, transfer the property tax base that you had from your previous home, and have a tremendous amount of savings. So what this proposition is going to do, it's going to make it even more exciting for everyone, It is going to be, again, if you're 55 or older, or very relevant to this fire season that we're in right now, if you're a victim of the fires and your home has burned down, as of right now, if you try to buy a new home, you have to buy a new home with brand new property tax base. Maybe you've lived in your home for 20 years and your property tax base is very minimal, but once you move, you're gonna have to pay 1.25% on average, at least here in LA, of your purchase price on your new property for your property taxes, which could be making the purchase, very much more unaffordable. So if you're disabled, you're also going to be included into this bill. Has to be severely disabled. So there's obviously some rules and regulations around that. But the great thing is if you're disabled, if you're a senior, 55 and over, to me that's not a senior, but consider yourself a senior at 55 through this. And if you're a victim of the fires, you're going to be able to transfer your property tax base 3 times, and you'd be able to go to any county, anywhere in the state. This is really going to open up a lot of transactions and help a lot of seniors who want to move closer to their family have that opportunity to be able to do that now much easier. Currently with Prop 60 and 90, you cannot buy anything. You cannot buy a property for $1 more than what you're selling your property for. So it has to be the same value or less. With this new proposition that will be on the ballot in November, you're able to buy a more expensive property. If you do, you'll pay the full property tax on that difference between what you sold for and your new value, but you get to keep your property tax base for everything below that, which is awesome. So that's all the good news with that coming along. I hope you guys will support that. There's one downside to the proposition, which had to be written in to really make it happen and make it a revenue generating item, which CAR hates to take away any rights from homeowners, but there's one negotiation that had to be made to kind of make this work. So currently, if you're inheriting a property, the property tax base also will transfer to you. Now this is going to change. If you're being inherited a property, you're inheriting a property from your parents or grandparents, you will only be able to keep that property tax base if you are living in the property or are going to be living in the property. So we don't want to make it, we don't want to kick anyone out of their home because property tax bases are rising and you would have to leave your home because of this new proposition. But if you're having it as an income property and it's just income, then that was the negotiation, unfortunately, they had to make to say that, that you're now going to be paying the new property tax base on that property. So still overall, we think it's a great bill that we would love everyone's support on. So that's Prop 19 coming up in November. These sessions are recorded on our YouTube channel. So if you search The Collective Realty on YouTube, as well as we're on Facebook Live right now, feel free to ask questions on Facebook Live or through the webinar. We have quite a few guests today. If you have questions, there is a question tab to ask. Please feel free to use that. You can also use the chat function. All of the panelists will have access to see that, and we'll definitely do our best to answer every question that you have for us. And feel free to come back, to review some of this great information. So our next session that we're going to be having after today is for first-time home buyers, called LA Homebuyer Seminar, and it's lahomebuyerSeminar.com. That's going to be on Saturday, October 3rd at noon. And you can RSVP for that. I'm going to put it in our chat function. So if you're interested in what it's like to buy a home right now, whether you're experienced or a first-time buyer, we're going to go over what that looks like. But today, we're talking specifically to our multifamily owners. We have a new eviction moratorium that's been put on by the state that we're going to be addressing and filling you guys in on. I'd like to introduce our director of the Collective Commercial, Will Tiao. An investor himself. He's a really, really great agent, role model for myself. And I'd like to give the floor to you, Will. Take it over.
Thanks, Anthony. Hey, everybody. I hope everybody is doing well out there. It's crazy times, right? Felt first like we were in the zombie apocalypse. Now it feels like we're a little bit end of days. I can't really tell what's going on. All I know is I have COVID sideburns going on, as people keep mentioning to me on my Zoom calls, because it's hard to get a haircut nowadays. Anyways, it's good to see all of you. I see a lot of familiar names. I'm glad you guys are able to join us today. So as you know, if you've been with us now, we've been doing this now for 3 years, and there's a certain rhythm, to how we do things. Typically, we give you guys, kind of a legislative update. Then we talk about what's going on in the property management market, and then we talk about stuff that's going on the brokerage sales side. And then we do a wants and needs section, for anybody who has wants or needs, and we talk about some of our on-market and off-market listings. But today we're going to mix things up. Our speaker today, Eileen Kendall, who I'm really excited to introduce, has to leave a little bit early because, like all of us who have school-age kids, like schools are like kind of making ad hoc decisions about where you need to be and what needs to go. So she's going to have to leave us a little bit early to handle something with her children's school, which I also have to do as well. But what I'll do is at the end, we'll come back and do all the market updates, which there are quite a few. So you want to stick around for that, as well as some really exciting off-market listings that we have coming up. So with that, I'd like to introduce Eileen Kendall. Attorney Eileen Kendall has been practicing law for over 15 years and has found that clients truly appreciate the time and effort she puts into every aspect of their legal needs. She is admitted to practice in the state of California and is able to appear before all California federal district courts and Ninth Circuit Court of Appeals. She has been practicing in the field of litigation with a particular emphasis in real property and business since 2002, and she has successfully prevailed in both appeals and trials. I wanted Eileen to come speak to us today specifically about managing rental property in this COVID-19 crisis. And, we have always a lot of investors and landlords on this call and people who want to be investors and landlords. And I myself am an investor and landlord, as many of you know. So I'm very excited to have Eileen speak to us today. The way we're going to do this is a little bit different. Usually we have our speakers speak and then do Q&As at the end. Eileen has set it up so that she has different sections to talk about. So at the end of each section, we'll do a Q&A specifically for that area that she's talking about right then. And so with that, I'd like to introduce Eileen Kendall.
Good evening, everybody. Like you said, my name is Eileen Kendall. I own Kendall Law. I have had my practice for 4 years. I practiced for a very long time for the man and went out on my own because time was important to me and I couldn't manage my own time with somebody else telling me what to do. So I have a slideshow presentation. What we're going to cover today is kind of a couple of things about managing property in this time. Some of the stuff you might know, but how to deal with amenities, showing properties, repairs. Then I'll briefly talk about the LA County moratorium. Then I will talk about the new AB 3088, which is called CITRA, S-T-C-T-R-A. And then I will talk about the Federal CARES Act and how that relates to CITRA. So I'm going to share my screen. Let's see. Oops. Can everybody see that? Can you see it?
Yep, we're good.
All right. These topics come from frequently asked questions I get from clients. One is, can we access a unit for repairs during the pandemic? And the answer is yes. However, you need to make sure that if you're doing the work and it requires face-to-face interaction, that you're following the CDC regulations on social distancing and wearing a mask, making sure that areas that have been entered and touched are, cleaned. And the repairs need to be essential. It can't be just going in to harass a tenant just because you want to get it. And I have landlords that want to just go into places to check it out, but it needs to be something that has to do with health and safety, usually heating, plumbing, habitability issues, because you want to limit going into tenants' property if you don't want to go in, if you can avoid it. You also want to make sure that you're posting social distancing signs at the entry of any multi-unit building. And you need to tell the tenants of the dangers associated with entering a property. It's kind of similar to if you're showing a property as an open house. It's not really an open house anymore, but you have your best practices and making sure that everybody's aware of the risks. And then it's better to show or to go into the property if a tenant isn't home, or make sure that there's not more than 1 or 2 people inside at the same time. If it's a property manager and a vendor, you want to make sure that you're limiting the number because you want to still social distance. And it's the same with showing property to prospective tenants. But you should consider trying to offer virtual showings. You could do something on Facebook Live or Zoom and walk prospective tenants through the unit. But if you have to physically show a property to a prospective tenant, again, try to arrange when the tenant isn't home. If the tenant is home, make sure to social distance and have no more than 2 prospective applicants in an apartment at a time. Even if the tenant is home, maybe ask them to stand outside. Depending on the type of property, same with when you're showing a listing, you want to maybe have the windows open, the doors open so that there is air flowing through the property. Things like that to make sure that, you know, you're limiting exposure. And then what do you do about common areas? I've gotten this question more so in the beginning than now because things are opening up. But if you believe that you can't maintain the fitness center or the pool or whatever common area there might be without, if you can't do it with following the CDC guidelines, you can temporarily close that amenity. If you do so, you need to make sure that you're posting signs and telling the renters that they're unavailable due to the federal and state guidelines. Laundry services are considered an essential service, so you want to keep your laundry areas open, but you definitely want to make sure that you implement more frequent cleaning for the laundry rooms. And you do not have to adjust the rent if you choose to close amenities. In the beginning, like I said, I got these questions. If we don't open the pool, because if you open the pool, you still have to post all the signs and make sure that you're putting people on notice of all of the rules and regulations. And some of my property managers like, that's too much of a hassle, I'm just gonna close it. You do not have to adjust the rent for those closures. And finally, the biggest one that I had received about COVID and tenants is, if a tenant tells us that they have COVID, do I have to disclose it to other tenants? No. 1, there is no duty to disclose that to other tenants. And 2, it is a violation, especially if you're giving the details of who the tenant is, what apartment there is, of constitutional rights of privacy. But you do want to make sure that if someone in the building is tested positive for COVID, you're increasing the cleaning in the common areas. Because obviously they should be quarantining, but you can't be certain that they are. If they go check the mail, you want to make sure that you are sanitizing that area, or if they're going to the laundry room. So you want to definitely make sure that if a tenant in a building has notified you that they've tested positive, that you are cleaning those common areas. So those are just kind of some basic things about being a property manager during this time, separate from all of the eviction stuff. Does anybody have any questions?
Are there any questions? I know we have a question in the chat about the 15-day notice, but I think that's going to have to do with AB 3088, so we'll wait to answer that question at that time.
Yes.
Are there any specific questions? I know I have some property managers on here because I asked my property managers to come. So are there any property management questions specifically? You answered mine, which was the one about the COVID tenant, because we've had a few of those cases, and we were wondering about what to do in those scenarios. Are there any other property management questions that people might have with regards to any COVID related issues? Someone just asked, what is the potential liability in having more than 2 potential in a unit? I'm not sure what you mean by 2 potential what? 2 potential?
No, I think what I had said is you want to try to limit how many people are in a property at a time, whether that's for repairs or for showing to a prospective tenant. I always say everybody can sue for anything that they want, but proof is what they're going to have to show at the end. The liability, I suppose, is if you packed 3 or 4 people into a small apartment and somebody gets sick, that they're going to turn around and say it's because you didn't follow the CDC guidelines for social distancing because there was so many people that you couldn't be 6 feet apart, that somebody could say that because of that, you're the cause of them contracting COVID-19. It'll be a very hard thing to ever establish because then you have to really prove that that's the only place you ever were in that time period, but that's the potential liability. If you're in somewhere where you cannot social distance because of the amount of people, you want to limit the amount of people in that space.
Okay. Any other questions for the social distance sign at the front? Is this just to reduce liability or is it a must?
I think that it is a requirement in multi-unit buildings. I got my information from the apartment association and I can't remember if they said must or may. I would do it.
Yeah, just to let you know, we do it on all of our buildings, and especially ones that we're in the process of selling. We make sure that we put those signs up, in a public area. Any other questions on the property management front? If not, you can feel free, as we move along, but let's go on to the next section.
Okay, so we're going to talk quickly about the local eviction moratoriums because in my mind, these are less important than the new AB 3088. Los Angeles County, despite the passing of AB 3088, or whatever, Citra, I'll just call it Citra because I'll never remember the numbers. Because in Citra, it pretty much said that local ordinances couldn't be extended, but LA County decided to extend theirs now through October 31st. And one thing that they did, which they should have done a long time ago, is they made it the baseline for all cities. In the beginning, it was very confusing for property managers and owners to know what applied to what, because every city pretty much had their own regulations and some of them would match the county, others wouldn't. Which one do you use? Now it is all cities in LA County, if they have a moratorium, the baseline is what the county's is. If a city has a more stringent rule, then they can go with that, but the baseline is what the county says. And basically through October 31st, for residential and commercial tenants, which includes mobile home spaces, you cannot evict for non-payment of rent due to COVID-19, lease violations related to COVID-19 for unauthorized occupants or pets or a nuisance. Now, that's an interesting one because you find that you have unauthorized occupants. Well, do you just consider that it's probably because somebody is, having to shelter in place there or somebody is sick? It's a really fine line on if they're just violating the lease to violate the lease, or they're just having a pet in there to have a pet, versus them rehabbing it due to something related to COVID. And the other evictions that are prohibited are anything that is no fault. You can't evict for any of the just cause no fault reasons that are set forth in the Tenant Protection Act of 2019. It also prohibits rent increases in LA County's rent stabilization ordinance, as well as mobile home spaces subject to the LA County mobile home rent stabilization. And I believe that prohibition is for 12 months after the expiration of the emergency orders. Landlords and property managers can't also impose new pass-throughs or charge late fees, interest, or any related charges for unpaid rent accrued during this moratorium period. That moratorium period is March through now October 31st. Okay, any questions on the local? There's lots of city ones. They're all questions on LA.
My screen froze for a minute. I don't know. Were y'all?
Yeah, mine did too. Mine did too. Eileen, you may have to repeat what you just said.
Yeah.
Okay, I was just saying, is there any questions about LA County? Now, I understand that there's lots of different I took the screen share off. I don't know if it's because of something. I usually don't ever have any internet connection. I'm hardwired, so I don't know why it's doing that. So
yeah, it's happening to all of us. Like it kept on freezing.
Yeah.
And
okay. So what I'm going to do is I won't screen share. I'll just kind of go through my slides. And if you guys want the slideshow afterwards, I can give it to you in case that's part of the problem.
Yeah,
I guess there is I mean, obviously you're going to get into the state AB 3088 right now, but I guess there's a lot of people asking me, like, what should I follow? Because it feels like there's a city guideline which says that, you know, September 30th is the end date of the eviction moratorium. Now we've got the county one, which is October 31st, but then you have this new state one, which you're about to talk about. So what is it?
All right, well, why don't I just go through the Citra rules, and then we'll try to figure it out, because that's the question of all time. What do I follow?
And someone said, and there's the federal one, the new CDC moratorium. So,
yeah. So give me just a minute. I have to get out of so I can see my slide. So AB 3088 is what they're calling Citra, C-T-R-A. And with Citra, there are two time periods in question. You have the rent that is due from March 2020 to August 31st, 2020. And then you're going to have a separate period of time for the rent September 1, 2020 to January 31st. And that's important because there are now different notices with different language depending on the time period when the tenant didn't pay rent. And interesting enough, I got a question today from one of my property managers saying, typically when they take rent, they use it and put it to the furthest in arrears. So if they owed for March, April, May, decided to pay in June, that would cover the March rent, and then so on. Well, based on this, I think that practice probably needs to change, because the time periods for the rent and what your rights as an owner are different with respect to those different time periods. So the first time period is March to August. And there is a notice that has special language, and it's now no longer a 3-day notice. And if you served a 3-day notice at any time since March, it's invalid because this is retroactive and you need to start over. I have had to dismiss several cases that had been done in the very, very early stages, non-payment of rent, to reserve the 15-day notice. There is a notice called an informational notice that has to be served on all tenants that haven't paid rent between March and August before you can serve a 15-day. They can be done in conjunction, but you cannot serve the 15-day without giving this notice, this informational notice. And you have to include the blank declaration of COVID hardship along with this 15-day notice. So you serve the 15-day notice and you wait your 15 days, which doesn't include weekends or judicial holidays. So really it's more like 30 days, not 15. And if the tenant returns the declaration, and if the documents are required because there is a high income earner, then the landlord can never evict that tenant for non-payment of rent between March and August. So all they have to do is return that declaration and you can no longer evict them for this time period. You can go after them in small claims court next year sometime for that difference of that rent that they're owed, but you can't seek possession. It's about possession, right? It's not really about the money. It's about getting possession and putting somebody out on the street is what their concern is. The rent can be collected in small claims after March 1st, 2021, and they have said that the small claim limits have been extended, the statute of limitations has been extended, and the times you can bring a claim in small claims is kind of thrown out the window. So as a corporation or some entity, you could only bring like 1 or 2 claims for 500. That's not going to be applicable anymore for these types of cases. If the tenant doesn't return the declaration or the documents that they're a high earner, the landlord can proceed with filing a eviction for possession after October 5th, 2020. Now, I talk about these high income earners. So if the property manager or owner had information from any time prior to COVID, so a rental application, and there's no time limit on it, it can be from 5 years, 2 years, 6 months. If you have evidence that that person earned over 130% the median income or over $100,000, you can ask them to provide documentation that they've really suffered a decrease in income due to COVID. Whether that's a W-2, a statement from an employer. For instance, I have a client that has a property where the tenant, the mother of a YouTube rapper, and has a very high income, that has decided not to pay rent because they've suffered some kind of income distress from COVID. I just wrote a very stern letter going through all of the daughter's endorsements and everything else to really say that you probably haven't suffered such an income loss. Now, it's a high rent amount because it's a big house and whatnot, but you really now have to show that they've really suffered it and can't pay rent. Because again, if you can pay the rent, you need to pay the rent. It's not just a free-for-all for anybody to not pay the rent. So if they don't do the declaration and provide the documents, after October 5th, theoretically, and I say that because the courts still don't seem to want to process things, after October 5th, they'll be able to process those cases for non-payment of rent for possession. Then we have the time period between September 1, 2020 and January 31st, 2020. So again, you've already served the informational notice, hopefully, because you figure if they didn't pay rent, they can't pay rent now, they probably didn't pay rent before. If you haven't already served the informational notice, you'll want to make sure that you're including that with the 15-day notice. This 15-day notice has different language than the one for the other time period. So you want to make sure that you're using the right notice. There's actually 6 different notices on the California Association of Apartment Association because there's 6 different ways that things can happen. So again, you wait your 15 days without holidays and weekends. If they return the declaration and the documents this time, the tenant can't be evicted, but only if they pay 25% of the rent for that time period by January 31st. So there's a 2-part. They have to do the declaration within the 15 days, and then by January 31st, they need to pay the 25% of that rent that's due for that time period. If they don't do either one of those, then you can proceed with the eviction October 5th. That's really if they don't return the declaration, right? So if they don't return the declaration, you can proceed. Now, if they do the declaration, you just have to wait and see if they're going to pay that 25%. If they don't pay the 25%, you can file an eviction after February 1. If they do both prongs, if they do the declaration and pay, again, you can never seek possession for that rental unit because they've complied. But again, you can go back to small claims court for the difference of the 25% and what they owe. So that's why it's really important to understand that there's 2 different time periods. And that's why when the client asked me today about, well, usually I just apply it to the most farthest away default. Well, that's not going to work if you're trying to track what payment you have a right to. So I would say that if you do that, I would change that practice for right now. And make sure that you're counting whatever payment or partial payment is to the rent that tenant wants you to apply it to. So if they make a payment in September, do not go apply it to anything during the past time period because it will really affect what your rights are. And as I said, there's this informational notice. It's about, I've typed it up, it's about 2 pages, maybe 3, depending on how you type it, that has to be sent to all the tenants that have not paid rent to date by September 30th. If you don't do that, you cannot serve your 15-day notices. So make sure that if you have any tenant that has not paid rent, that you're giving this informational meeting or this informational notice. You don't have to serve the 15-day notice. Some people just want to hold off on that and wait, because especially if it's for September, well, do I have to serve the notice every single time every month? Well, the answer is yes, and they're required to continue to provide a declaration, especially if there's any changes every time. So some of my clients are just waiting until the end of the time period, and then we'll do a notice. And each of the notices specifically say this doesn't include the other time period, and the landlord's reserving their right to collect for the other time period. So they're very specific. So what is allowed under Citra is the evictions that can take place, and we thought in the industry that we could do them now, but talking to my colleagues, they're still being held up, is matters that a tenant was holding over after lawful termination that happened prior to March 1st, 2020. If it's for non-payment of rent, the tenant failed to comply with the declaration procedure, or the landlord has an at-fault reason. And this is most of my cases right now, but the court still isn't processing them. I have a tenant that wanted to describe how they wanted to kill another tenant and describe where they're going to do with the body, and the court wouldn't issue me a summons saying it wasn't enough of a health and safety risk because they didn't file a restraining order. So this case is still waiting to be heard. It has nothing to do with non-payment of rent. So if you have something that's at fault, termination of employment, you have a resident manager that was supposed to leave and didn't leave, or you have other lease violations that aren't related to unauthorized occupants, then you theoretically should be able to file and proceed those. They can't evict for no fault reasons except where it is based on an intent to substantially remodel to comply with health and safety laws. So you can't evict if you want to substantially remodel unless it's to comply with some governmental order or fix some health and safety issues. Again, it's a 15-day notice. Your 3-day notices are no longer valid. I suppose if you have a tenant that didn't pay rent in January and February, and then, everything hit the fan and you didn't do anything with it, you could do a 3-day notice for those 2 months and try to proceed with the eviction with that way. But for everything else, it's from March on, it has to be a 15-day notice. Like I said, there's 6 different notices because you have the 2 different time periods, and you also have what we're going to talk about in a minute, the CARES Act. So what they've done is each has different language. And then if it's subject to the CARES Act, then you have even more language that goes into it. So there's a bunch of different notice options to make sure that you have the right one, because there's very specific language included in each of them. So we'll just cover the last section I have, because then we'll go into kind of how they interact together. The CARES Act is the eviction moratorium that was issued just right after Citra was issued. And basically, it's putting a moratorium on properties that are subject under the CARES Act. So federally backed mortgages, loans, HUD, VA, Fannie Mae, Freddie Mac, or properties that participated in federal subsidy programs like Section 8, public housing, disabled or elderly housing. And why this is different and important is while you can, if the property is subject to the CARES Act, while you can require performance of the payment of rent for 15 days, you can't tell them to vacate until 30 days. So that's where that language is going to be different, is that, a 15-day notice says you either need to pay or vacate within the 15 days. If you have a property that is subject to the CARES Act, you can tell them you need to cure within 15 days. If you can't cure and you don't do the declaration, then you have to vacate in 30 days. So that's why the language is different. Oops. Get my slide to move here. That kind of is the two different moratoriums plus the LA County. So how do they work in conjunction? It's going to be the most restrictive, and it's kind of how LA was doing it. So if your first question is, you have a ordinance in Manhattan Beach that has an eviction moratorium that says one thing, and you have the LA County moratorium that says another. If Manhattan Beach has lesser restrictions, you have to comply with the county. If it is more strict than the county, then you can go with Manhattan Beach. Now, how does that now play with Citra? They're kind of, you kind of have to marry them together and see what the different restrictions are. And for the most part, under the city or the counties, it's prohibiting certain evictions. It's not telling you about the notice period, etc. So you just want to make sure that, my understanding, and I went through like Santa Monica for a client just recently, is even though Santa Monica says you can't terminate a tenancy for non-payment of rent, you can still give that 15-day notice after the expiration of Santa Monica. So Santa Monica expires, as I checked the other day, September 30th. Now I understand now LA County is October, so we'll see how that goes. But you give the informational notice now under Citra, and then either October 1, if that's where that local moratorium is, or I'm just going to say just go with October 30th because that's the county's baseline now. So November 1st, then you can do the 15-day notice. Under Citra, these local ordinances are not supposed to be extending their moratoriums. They're supposed to stop. I don't know why LA County decided not to, but they're not supposed to. So it's a wait and see. I'm going to say for most cases, serve your informational notice on October 1 or November 1, do your 15-day notices for both time periods. But I'll field any questions because that's how I understand how they're going to work together. But I'll be happy to answer any questions on anything related to these.
Well, as you can see, it's super, super complicated, all these different laws and how they interact. That's why everyone out there should absolutely be consulting with a professional like Eileen, a lawyer. Obviously, even property managers like myself are constantly calling our legal counsel nowadays to figure out what's going on. I have a number of questions that I think will be, very relevant, and we have a few questions as well.
Okay, great.
So, the first question is this. Now, as you mentioned, all the debt now, they have reclassified between March 1st and August 31st. Any debt that's delinquent from a tenant is now considered civil debt, right? You mentioned that. It's
a consumer debt, yes, but that's only if they do the declaration.
That's only if they do the declaration. Okay?
That's how I understand it. So if they do not comply with the 15-day notice, if they don't pay it within the 15 days and don't do the declaration, then you can proceed to, like you would normally in eviction court, possession and past due rent.
Understood. So this is the question, because, and this is a very real case for us. Like we have tenants who haven't paid for 5 months.
Yeah.
And small claims court limit is $10,000.
Not anymore.
Not anymore. Okay,
yeah,
that's
so I kind of briefly touched that. So in order to because not only are you capped at a certain dollar amount, you're capped at how many times in 1 year you can bring a case.
Right.
If you're a property manager that has 500 doors and half of those haven't paid rent, what are you going to do? So yes, they have kind of thrown that out the window. So that the owners and managers can collect that in small claims. Okay,
that's good information. Grant has a question on AB 3088 and emergency rental assistance. So he's asking, so LA City and the county, they're both offering certain emergency rental assistance. In LA City, it's capped to $2,000, $1,000 a month. He's asking if a tenant is granted that emergency rental assistance, does that $1,000 go towards their 25% required payment?
So that's if it's between September and January. The way that I understand the code is they don't have to pay 25% on the full 9 whatever months there is from March. They only have to pay 25% towards that second period of time. And yes, that's my understanding, is any landlord that wants to file an action will have to account for any assistance that they receive, whether it's from the federal government where they got grants or whatever it was, or loan forbearances. They're going to have to account for that when they're trying to collect the debt. So while there isn't anything clearly that states that, I'm going to say yes, that's going to be, it's not going to count as towards 25%. What it's going to be is, so say they owe $2,000 for September 1 and you get $1,000, then the only amount due is $1,000. So then you have that for the second month, and then you're going to add the other months as full, and then it's 25% of that total. So
right.
I'm not going to say,
that's a big question I'm getting from my clients, is like, is it 25% a month, or is it 25% of the entire September to January 31st?
That's
period?
how I understand it. I've read it a couple of times, and it's for that period of time. So basically, the way I think the statute says is 1.5 months of rent that they have to pay.
Okay.
Yep.
So, and that can all be paid by January 31st.
Yes, there's no requirement that they pay it before then. So basically, you have to wait. If they serve the declaration, then you sit and wait till January 31st to see if they paid that 25%.
Lovely. Okay, so that's something. Okay, so the next question Grant has is regarding AB 3088 and the $100,000 threshold. What if the high income person is a co-signer, not the tenant themselves?
I think it's anybody that's on the lease.
Okay.
So if you have 4 people on the lease, it's going to be in the collective that the household income exceeds that 130%, or at least it can't be any, it has to be above 100,000.
Okay, good to know. Good to know. If someone has another question, if a tenant moves out, and we had this happen to us actually, if a tenant moves out and there's rent delinquent owed, and it obviously is past what the security deposit is, do you need to wait until March 1st, 2021 to go to small claims court?
I'm going to say no, because it's not about possession. You now have just the breach of the rental agreement. But that's a good question, because I don't know if that has been contemplated in the statute,
Right.
because it just says that you can't seek repayment of the rent until after March 1st, 2021, but that's only if the tenants are still in possession. So it's not something that's really been contemplated. And in my interpretation, it would be, this is all about keeping people in their homes, right?
Yep.
If they're already out, it doesn't matter.
Right. Right.
So I guess that's something we'll have to wait and see.
Right. We literally had this happen to us just like last week, where we had somebody who owed us 4 months of rent,
Yep.
and then they left and they still owe us 4 months of rent. But yeah, we were wondering about that question. So that's a very good question. Another question. Can notices be sent to increase rent, or due to the California state of emergency and price gouging law, you can't?
So my understanding is the only rent freeze that is applicable right during any of this were rent increases. And I get this question. I have one particular client, property manager, that asks me almost every month, can I increase the rent? Yes, unless it is under the mobile home or Los Angeles rent stabilization ordinance. Those are the only properties that cannot have a rent increase. But note that when he called me the other day and asked what the rent increase could be, it's only 5.69%.
Because of AB, the other, other rent.
Because the API is so low right now, and he's like, that can't be right. No, I checked a couple of different sources, because it's 5% whatever plus the API, and he's like, well, usually it can be like 8.5. Well, right now it's 5.69%.
Wow.
So do you want to raise your rent or wait?
Right. Exactly.
Because now if you raise it now at that low, if the, goes back, the API goes back up, you can't raise the rent again for another 12 months.
Right. Correct.
Judgment call.
Exactly. You have to consider all your different options.
Right.
I mean, so one question we're getting right from certain landlords is like, they're scared to rent right now. They're scared because they're worried that if they rent to somebody and then they move in and then they immediately don't start paying, right? They could be in a world of hurt if they're in that position. But there's, you're dealing with kind of you have to deal with fair housing laws, right? In terms of what you can turn them down. So question about that, like what are legitimate financial reasons to turn down someone and what are not?
So as long as you are applying the same qualification to every single applicant, a landlord has the right to look at income and, employment history to make a determination of whether a tenant you want to rent to a tenant. Now, you can't just hand pick one or two to do that to, but if you're using that uniformly throughout and you're looking to somebody, so I would think this is less of a concern now than it was like 2 or 3 months ago because the economy is opening up. But if if your standard is to look at the last 2 months of income or what their job is, and you're doing that to everybody and you see that somebody's a hairdresser, if you're making that same determination no matter what applicant it is, I don't think that that's going to be a violation because you're looking at the same criteria that you've always looked at, and then you can determine that you don't want to rent to that person. Again, like I said, I think I'd be more concerned about that a few months ago, but now hopefully because things are getting back, people are starting to get employed again, that it's less of a concern. But I wouldn't be, like I said, as long as you're using the same standard for everybody, you have that right.
Okay. Another question we have, what if a tenant is on a 6-month lease and you notice the tenant that you won't renew and they won't move? What are your options?
So that's a good question because under the county currently, if a lease expires, it's extended to the end of the emergency, which is October 31st. So I have a lot of people asking that too, can I just not renew the lease? Now, 2 things. One is, well, there's a couple of side notes to that. You can only terminate a lease if it falls within the exception of AB 1432. So if it's a single family or a condo and you don't have to have cause to remove or renew, because some leases are every year they do a new lease. So you have a written lease every single year, but they've lived there for 4 years. Just because it's a year lease, that CAR form is really irrelevant now because you can't terminate just to terminate with 60-day notice if it is a multifamily, because you now have to, under last year's rule, you have to have just cause. Right. And then under the moratorium, any lease expiring under the county is extended until the expiration of the moratorium.
Right. This person just said they were not in LA County, they're in Riverside. It's a multifamily 14 units. I don't know if you
Well, that's going to fall under the state law. So whether the LA County moratorium doesn't matter, but it does fall under state law. And if they have been in there over 12 months, under the statute, you have to have cause. You can't just terminate. So it depends on how long they've lived there.
It says only there 6 months.
Well, yeah. So under that, they don't fall under the protections of the Tenant Protection Act from last year. So you don't have to have cause.
Yeah. I would say if you have specific questions like that, you should probably contact Eileen directly. We're going to have her information. Again, it was at the top, and we're going to have it again at the end. If you have any specific, questions regarding any specific issues with your tenants. I know, for example, I was talking with another landlord tenant attorney that told me about a situation where it was a sale of a house, and the and the owner, like the seller, right, had arranged a lease back with the new buyer. So they sold the house, they closed the deal. They were supposed to only stay there for a month. They decided to stay longer.
Yeah.
And
that creates a landlord-tenant relationship.
Exactly.
Yeah.
Exactly. So, and they stayed for the whole state of emergency period.
Yeah.
So they basically stayed rent-free for 5-6 months. We had a situation where we had a judgment, an eviction judgment on a tenant for illegally subletting their unit.
Yeah.
That was in, we filed in January. We got the judgment in right at the beginning of March. Yep. COVID hits, and the sheriff's not doing any lockout.
They are now.
I know they are. We just got one.
I just got a lockout last week.
Yeah, we just had a lockout 2 weeks ago.
Yep.
And so basically, though, like what was galling to my owner was that basically because they were illegally subletting the unit, the tenant was making money.
Yes.
On the unit, and the owner was losing money.
I hear that a lot too.
So there's been a lot of really kind of messed up things during this whole process.
Yeah.
I know, Eileen, first of all, thank you for your time. Thank you for your information. I know you have to go. Is there any kind of last words that you want to say before you have to leave?
Well, I am running a COVID-19 special for landlords and property owners because basically I'm giving them bad news when they call, so I don't feel like I can charge them my full rate. For $75, I'll talk to a property manager or a landowner for a half an hour for the $75 and let them know for their specific case what they can and can't do. If you ever reach out to me for information, I usually have you on my list, and I send out mailing and information. Like I have a couple of individual owners that just own a duplex, and while she hasn't reached out to me, I had been talking to her several months ago. I now have emailed her to let her know that this new law. So I like to keep anybody that I am associated with up to date. If you go to my website, I do have a VIP link for real estate professionals, and that puts you on my mailing list as well. I usually do a monthly blog. Right now I'm doing a series on is an LLC right and how to use an LLC for buying property, which entity is the best for me. So it's like a 9-month series, but when these changes come up, I'm doing blogs on those as well. So sometimes they're more frequent. And that way your property managers and owners can get that information when it comes out.
That's great. That's fantastic. So we'll put all the information for Eileen Kendall on, for everybody to see, her email, her website, her phone number, and then that way you guys can reach out to her directly with any questions. If you want to stick around, I'm going to give an update on what's going on management-wise, brokerage-wise, in the market and whatnot, as we'll do our needs and wants as well. But we want to thank Eileen so much for your time and the information. So much going on.
It is, and it's complicated. And I have a stack of paper probably 2 inches thick from the various resources to try to make sure that I'm getting the most accurate information. But it is confusing, and I'd be happy to talk to anybody that needs some information. And I really appreciate you allowing me to speak for your group today.
Absolutely. Thank you.
You're welcome.
So much, Eileen.
You're welcome. Have a great night.
Bye.
Bye.
Well, that was fantastic. It's always great to get people who are on the ground, hearing what's happening, obviously legislatively, you definitely don't want to do this without a professional. I will say, we have had more management requests, inquiries in the last 3 weeks than we've had all year. And I think that's because so many people are trying to figure out what's going on. They realize they need a professional to help them, and there's no doubt about it. And it's just we're constantly staying up to date, as to what's going on, because there's so much interplay between the federal, the state, the county, the city. Every area has their own take on this whole thing. So it is really, really crazy. Before I get into my stuff, is there anything, Anthony, you want to say after hearing all that?
Yeah, no, I agree. It's like you have to have a management company behind you protecting you right now. It's just too insane the amount of changes that are happening so fast, and to stay on top of it. Like all of you guys who are watching today, good for you, because I'm sure everyone who's been on this call so far has learned something new, and we'll continue to keep bringing you updates as they come along. So yeah.
Absolutely, absolutely. So you know, I don't want to talk too much about, you know, the propositions, because I think we're going to end up doing a seminar specifically on the two major propositions that are going to affect landlords, and that's Prop 15, also known as the split roll. The idea behind it is that properties that are worth 3 million or more will basically be cut out of Prop 13 and will no longer be able to hold that original basis and will be assessed at market. I don't remember what it's being called, what the official name is called, but I know it has to do something with education. The argument is that the income from the new tax would go towards education. So that's something to be aware of, obviously, if you're a commercial owner, a commercial property owner at all. And the other thing is Prop 21. Prop 21 is basically a redo of Prop 10 from 2 years ago, has to do with rent control. And the idea, once again, it's basically a redo almost, but with some slight adjustments, which would basically lift the Costa-Hawkins Act for certain, for most municipalities, which would mean that there could potentially be vacancy control. Right now, per Costa-Hawkins, there's something called vacancy decontrol, which allows, if you say you have a rent controlled unit, and say it's a 3-bedroom, and you have long-term tenants and they're renting it for $1,000, and the market's $3,000 or $2,500 for a 3-bedroom, right? So, you know, under rent control, obviously, while they're there, they're paying their yearly bumps or whatever. Once they leave, as of right now, under current law, landlords can bring the rent up to market, you know, up to that $2,500 in this example. Under Prop 21, that could potentially no longer be the case. They would allow municipalities basically to potentially keep the rental basis up to only 5% increases from where it was at.
That would be ridiculous. I mean, we have some 2-bedrooms that we see in West Hollywood being rented right now for $500 a month. So that owner would only be able to increase it by 5%. It's just not
it's
right.
like, and I think it's like a total of 15% over time, over like the next 3 years.
Well, it's like somebody's going to win the lottery.
Considering a 2-bedroom, what did you say? 2-bedroom in West Hollywood is like going closer to 3,000, right?
Yeah.
So it's something all of us should be aware of. And
it also can put more rent control on single-family homes. So I believe if you own 2 homes or more, it'll bring the rent control laws onto single-family homes. So,
correct. So all of us,
condos and single-family homes, yeah.
Exactly. So all of us who are in this world really need to be aware of it and get yourself educated on it, both Prop 15 and Prop 21.
Yeah.
Regarding management, like I said, we're lately getting a lot of requests on property management for the obvious reasons that we've been discussing on this call. But something very interesting is also happening too, which is that I think because of, you know, the uncertainty, tenants are also very uncertain as to what their rights are. And what we've noticed, right, because obviously during this entire COVID-19 period from March until now, we've had various, you know, tenants, you know, be delinquent and whatnot. And we were running about between 90 to 92%, you know, collection rates, you know. So that meant about 8 to 10% of our tenants were not paying their rent. Some of them were getting months behind. All of a sudden this month, we've seen a large percentage of our tenants who were behind get caught up or make serious efforts to get caught up. And we're now at, I think, 95%. So we're at almost pre-COVID levels, not quite. We were at like 98, 99% pre-COVID. But now we're at 95%. So we're above our 90 to 92%, which is counterintuitive, right? Because I think a lot of people thought with the end of the stimulus, a lot of people would not be paying rent.
Yeah.
But what's interesting is we're not seeing that, at least in our case. And I'm also keeping tabs with other property managers, and I'm hearing very similar things. And I think it's because of the uncertain regulatory environment. Tenants also, like I said, are not totally aware of what's going on. And now they realize they do have to pay something. So with that, you're starting to see more tenants pay rent, and we're now up to 95%, which is like very interesting, because I think this having effects on the brokerage side, right? Because I think right now there's a lot of concern in the market, in the multifamily market, about like what's happening. And, you know, I am seeing our kind of turnkey listings, you know, and a lot, I'm seeing it across the market, is that multifamily is not trading as much because there's so much uncertainty regarding these eviction moratoriums, right? People are worried, like, I'm going to invest in an asset I'm not going to be able to collect. But the fact that we're getting 95% collection, and I know for a fact that we're getting over 90% collection in most of the market, that tells me that this market class has actually been really stable through this whole pandemic. If you talk to other commercial realtors in other markets, i.e. retail, i.e. office, i.e. hospitality, you know, I mean, many of them are saying that their collection rates are much, much lower. You know, in some cases, less than 50%. So multifamily, especially B and C class multifamily, continues surprisingly, I think, counterintuitively, to be one of the safest asset classes. And it's just something for you to do. Anthony just put up a poll. It says, what percentage of your tenants did not pay rent for this month? Now we put April, it's actually, you know, we should probably do it for September. Right?
Yeah, so I wasn't able to edit that, but if you want to just say for this last month, you know, for September, yeah, sorry.
Yeah, yeah, no worries.
Answer, that'll be great if you are a property owner.
Yeah. So let me share with you guys some of our on-market and off-market listings that we have. And for those of you who have specific wants or needs, this is your time to put it in the chat or the Q&A. If you have anything you want to, if you have any wants or needs or something you want to put out there as well. So I'm going to start sharing mine. Can everybody see? Let's see. Sorry. There we go. Oh, I think this is actually the wrong one. My apologies. Anthony, what flyer are you seeing right now?
I am seeing Parkview.
Oh, you are seeing Parkview.
Yeah,
good.
50K price reduction.
Okay, great. That's the one I wanted to show. Okay. So this is a 5-plex in Westlake. This is just south of Echo Park and Silver Lake, right next to MacArthur Park near downtown. It's definitely like kind of a very strong up and coming area. 5 units, 2 3-bedroom, 1.5 baths on the top of this. So there's a 4-plex in the front and a single house in the back. In the 4-plex, there's 2 3-bedroom, 1.5 baths. On the bottom floor, there's 2 2-bedroom, 1 baths. And in the back is a 3-bedroom, 2-bath house. They're all rented at market. There are 5 garage spaces as well that the owner is renting out for extra income. And then 5, so that's 5 garage spaces, and then 5 driveway spaces. So 10 spaces total. If you look at this, you can see the rents. Total monthly income is over 14K, 145. That gives you, it's being offered at 2,445. We just did a price reduction of 50K. That gives you a almost a 5.5 cap at a 14 GRM. So once again, you know, one of these kind of bread and butter, like, you know, completely, and it's been completely updated you know, new foundation, new roof, new electrical, new plumbing, new everything. So these are top of market rents, and it gives you a sense of like, you know, where things are trading, you know, what things are at least on the market for at 2445. Okay, so going to take out this one. Oh,
I'm gonna share the results from the panel. And it's, yeah, it's just like you said. When we did this a couple months ago, the numbers were much, much worse. There were a few people in the 20 to 30% mark. I would say a majority had a lot, 10 to 20%. But now we're just the opposite. We have most of the tenants paying 57% have all their tenants paid, 43% have 10% or less. Nobody above that that's on this call. So yeah.
Yeah, exactly. It just kind of confirms what we've been discussing. Do you see the Silver Lake one up now, Anthony?
Yes.
Okay, so this is also a 5-unit in Silver Lake on North Lafayette Park Place. They're all 2-bedroom, 1 bath. Average rent is $2,800. All 5 units are rented. What's nice about this one is that it's got a 3-car garage that has already been permitted to be converted into a 1-bedroom, 1 bath ADU. It's one of the first multifamily properties in Los Angeles to get this designation. They only started allowing this year, and literally this owner was like the first in line to get that permit. So once again, it's a turnkey property, new plumbing, new electrical, new roof, new you know, all new appliances. It's priced at 2.75. With the ADU, the GRM is a 13.97 and the cap rate is a 5.6. You can see here, like the income is, like I said, roughly about $2,800 a month. So you're getting about $14K. Once you add that 1-bedroom, 1-bath ADU in, you're getting 16 and a half, you know, 16,455. So, like I said, all the plans are ready. So if you're looking for something that you want to add some value in a great area, this is a great option.
Yeah,
So,
well, a lot of people don't realize that you can build an ADU on income property. They think it's maybe just for a single family home, you know, converting a garage, but you can absolutely still do it on income property. The last seminar that we did last week was all about ADUs. We had Stephanie Regal from Architecture 42 speak. So if you're interested in ADUs, she gave a really, really great talk that's up on our YouTube channel right now at the Collective Realty. So I would highly recommend checking that out.
yeah, Stephanie's great. I mean, she's, you know, her firm is an architecture firm. They specialize in ADUs. She actually spoke to our group, you know, a while back about ADUs. And also just, you know, for those of you who are interested in doing additions or, you know, thinking about construction or whatnot, great person to talk about, but she's been doing a lot of ADUs lately. Speaking of ADUs, and this, you know, is special to you guys. This is completely off market. Only you guys are seeing this right now. I am not disclosing this address unless you contact me directly. This is in Mid-City. It's near Olympic and San Vicente. Great area. It's currently a duplex, a 3-bedroom, 2-bath, and a 2-bedroom, 2-bath, both rented at market. But here we go. The seller is getting the permits so that you can build 2 ADUs in the back, an ADU and something known as a junior ADU. Okay, both will be 1-bedroom, 1-bath units. And what's nice about this is that once you do that, right, all of a sudden you have a 4-plex from a duplex, right? So, and he's offering this at 1.68 million, 1,680,000, but 4-plexes in the area are selling for an average of 2.2 million. Okay, and if you look at that income, you see why, right? I mean, 2 1-bedroom, 1-bath ADUs, one's going to get 2,400, that's with the parking space, and one 2,250 is without a parking space. And he's currently already getting 2,945 for the 2-bedroom, 2-bath, and 3,395 for the 3-bedroom, 2-bath. Once you get this all in, your pro forma cap rate is a 6 cap and a GRM of 13.7. So once again, this is a huge potential value add play for somebody. If you have interest in this, you know, I'm happy to share this with you. I just didn't want to share the address since it's an off-market deal. But if you're interested, you know, please contact us. We're happy to show it. We are anticipating a $200,000 cost to build each, so $100,000 each for each ADU, which is about standard. We were anticipating about $100,000 also on the Silver Lake property, on the North Lafayette Park Place property. So once again, mid-city duplex 168 with the potential for 2 ADUs. That's what I have right now. I can stop sharing. Are there any questions, thoughts? Does anybody else have any other things they'd like to pitch? If they have any needs, any wants? Anthony, do you have anything?
No, that's it for now for me.
Do we have any, there's no one else, you know, wanting to do any questions? You know, obviously, do you think you can put back up the slide with all of our information? Because
yeah, let me put that up right now.
Eileen's information, your information, my information, if you have any questions. Oh, one thing I do want to say is that our next session, I don't know if you know that name, but he is the godfather of tenant in common conversion. So TIC is a form of ownership, which allows you to take a partial ownership in a property. This is used very regularly in the San Francisco Bay Area, which is where Andy actually kind of started this. It's now becoming more and more popular in Los Angeles. We ourselves are going to be listing the newest TIC and the largest West Hollywood TIC, an 8-unit TIC in West Hollywood, only like less than half a mile from our collective office. So we're really excited to be bringing. Yeah, and they're gorgeous. I mean, they're all 2-bedroom, 1.5 bath townhomes, old Hollywood style. I mean, they're just like, you walk into them and you're blown away. Private courtyards, great, lot of outdoor space for people. You know, obviously very important in these COVID pandemic times. So we're going to be having Andy Serkin come talk to us. Andy is actually based out of the country. He's based in France. So we're probably going to do a morning session because he's, you know, he's going to be out of the country. So just with the time difference. So we'll be sending you all information on that. Here again is our information for any of us who are interested. I think that's it. I think that's a lot of information you guys are probably taking in.
Yeah, feel free to tune into our YouTube channel to listen again, and definitely will be up there. Check out some of the other topics that we have. And again, the next topic we have is with rents so low and interest rates so high. If you don't own anything yet, tune into how to purchase a home in today's market.
With rents so high and interest rates so low, I think you meant.
Yes, with rents so high and rates so low. Did I say it opposite? I don't know, the screen keeps cutting it out. We're losing each other here. We're going delirious. Oh,
Absolutely.
Yeah, my screen is going crazy.
Your screen is frozen, but we can hear you. We can hear you. So
okay.
Yes, definitely for first-time home buyers, definitely check it out. A TIC is also a potential option for first-time home buyers as well. You know, a lot of first-time home buyers buy into a TIC, so it's a great option for everybody. We're super excited about it, and you know, thank you for taking the time to learn. Thank you for joining us, and you know, we'll be in touch with you shortly. If you have any questions anytime, please reach out to myself or Anthony. Thank you again to our speaker, Eileen Kendall of Kendall Law, and feel free to reach out to her if you have any questions. I think Anthony is frozen. Okay, yeah. Nope, we can still hear you.
Oh, I don't know. My screen's frozen. But anyway, thanks, guys. Have a great week. Stay safe, and we'll see you next time.
Sounds good. Thanks, everybody. Bye.